My dear friends, Jayaraju to all of you. Happy Independence Day. On the eve of this Independence Day, I would like to share my views with all of you on the subject now, which is in hot debate. Supreme Court judgment on SC classification is fundamentally and factually flawed and a negation of the spirit of the Constitution, a case for review. My friends, there is intense nationwide debate, celebrations, and protests simultaneously over the recent judgment of the Supreme Court 7-judge bench on scheduled caste subclassification into groups on the basis of backwardness, delivered on 1st August 2024, overruling the 5-judge judgment in E.V. Chinnaya versus State of Andhra Pradesh 2004, in which the top court decided that the state legislatures cannot subclassify the scheduled caste for the purpose of reservations in educational institutions and public services, further deepening the divide among scheduled caste communities and weakening their collective voice and bargaining power in the dominant caste-based discriminative Indian society. It is to be noted that in this judgment, not only the subclassification of scheduled caste by the state legislatures is held legal, but also the observations made by some of the honorable judges with regard to the creamy layer aspect among SCs created a furor and intense debate, though these are not the part of the issues before the court and not binding on the government, but given rise to such possibility on the pretext of these observations or opinions, as the case may be. I will deal with the subject of creamy layer controversy separately. Anyway, on the issue of suggestion by some of the judges of a creamy layer among SCs and STs, angered the entire Dalit communities irrespective of the subcaste, and they are unanimous in opposing it, and even the political parties are forced to support Dalit voices. But as far as the judgment on SC classification, the ruling and the opposition parties are in a fix way and not able to come out with a clear stance either for or against it, and weighing options with wait and watch approach. In the Modi government is maintaining studied silence on the subclassification after the judgment stands in contrast to its strong position which it has taken before the Supreme Court in the month of February 2024, wherein it vociferously argued that both center and the states should be allowed to subclassify SCs and STs. But since this judgment applies only to the state government, the center has taken a turnaround position and not able to come out clear on this issue. And this difference was clearly visible when the Central Social Justice Minister, Mr. Virendra Kumar, dodged repeated questions by the press on its stand on subclassification judgment. And what is the immediate background of this judgment? The present judgment issue arose from a reference of 5-judge bench of the Supreme Court in the state of Punjab versus Devendra Singh and others 2020 against an earlier 5-judge bench Supreme Court judgment and E.V. Chinnaya versus State of Andhra Pradesh dated 5/1/2004, which categorically held that any further division of scheduled caste category is not permissible because it is a homogeneous class and state legislatures have no power to effect subclassification within scheduled caste, as it violates Article 341, in which only the president, that is Parliament, may issue notification after consultation with the governor, that is State Assembly of a state or union territory, specifying the list to be included in the scheduled caste under Article 341, subclass 1 of the Constitution. In the state of Punjab versus Devendra Singh and others, the issue before 5-judge bench was a challenge to Section 4, subclass 5 of Punjab Scheduled Caste and Backward Classes Reservation in Services Act 2006, wherein Punjab has provided Punjab government has provided that out of reserved post seats for SCs, 50% of the vacancies would be offered to Balmikis and Madhyabi Sikhs, which was based on the circular dated 5th May 1975. And the said circular was challenged and struck down by a division bench of Punjab and Haryana High Court on 5th August 2006. A special leave petition against the High Court order was dismissed by the Supreme Court on 10th March 2008, relying upon E.V. Chinnaya versus State of Andhra Pradesh judgment, which relied on the judgment of Indra Sahne versus Union of India 1992, wherein the Supreme Court held that it is permissible to make subclassification within the socially and educationally backward classes. Basing on this legal position, the division bench of Punjab and Haryana High Court held, we do not think that the principles laid down in Indra Sahne case for classification of OBCs can be applied as a precedent for the subclassification of subgrouping of SCs in the presidential list, because the very judgment has specifically held that subdivision of OBCs is not applicable to SCs and STs. Against this division bench judgment, the Punjab government preferred appeal, and 5 judge bench of the Supreme Court, appeal for Supreme Court in the year 2020 differed with E.V. Chinnaya versus State of Andhra Pradesh judgment, resulting in reference to the present larger bench of 7 judge bench led by the Chief Justice of India, Honorable Chief Justice D.Y. Chandrachud, which overthrown E.V. Chinnaya judgment and delivered a controversial judgment and with lone dissent judgment by Justice Bala M. Trivedi on almost every point in issue. Now, what is the essence of majority judgment led by Honorable CJI D.Y. Chandrachud? In his judgment, on his behalf and on behalf of Manoj Mishra, CJI held that SC communities are not homogeneous class, as ruled in E.V. Chinnaya judgment, in spite of having a common constitutional identity as SCs on their experience of social discrimination and untouchability. But that does not mean that there is no heterogeneity among them. He also cited that there were even instances of some sections of SCs being discriminated against other SC communities. Therefore, subclassification is permissible, but it should be based on an intelligible differentia. That means a clear characteristic that will mark one group as different from another and should have a rational nexus to the purpose of doing it. Further, the subclassification is subject to the judicial review, and the state should be able to justify it using empirical data. The Honorable CJI also held that subclassification will not in any way amount to tinkering with the presidential list and is not violative of Article 341, which confers exclusive power on the President, that is Parliament, to notify the scheduled caste, which is a bone of contention and is in conflict with the 9-judge bench judgment in Indra Sahne case 1992, which specifically held that subdivision of OBCs is not applicable to SCs and STs, wherein it clearly declared that any subclassification within the SCs and within the SCs which is declared so by the President under Article 341 would be a violative of Article 14, equality before law of the Constitution. However, the CJI stated that there are 6 judgments, all concurring with his judgment, and that means that the state can identify more backwards among SCs and subclassify them for separate quota within the quota of SCs. But he added a rider that while allowing subclassification on the basis of empirical data regarding the inadequacy of the representation of subclass, and the state cannot earmark 100% reservation for subclass. No wonder the other judges also echoed CJI on this aspect. But Justice B.R. Gawai, curiously the only judge on the bench from SC community, strangely agreed with the CJI on the question of necessity of subclassification of SCs, but his interpretation of Article 341 as merely a method of identification rather than a basis for reservation is nothing but a narrow view. a narrow view that undermines the original intent of the article to provide protection and upliftment of the most marginalized communities, that is, scheduled caste. With due regard to the Honorable Justice B.R. Gavai, that apart, his opinion on the extension of creamy layer principle to the scheduled caste fraught with several social ramifications and legal concerns as well. However, the lone dissenting judge, Justice Honorable Justice Bala M. Trivedi, made a forcible and a rational ruling, disagreeing with the majority on almost every point in issue. Firstly, she ruled that the bench referral of E.V. Chennaya case to a 7-judge bench was inappropriate and not in consonance with the doctrine of precedents and state decisions. It failed to demonstrate why the reasoning and rationale in E.V. Chennaya case was not correct. She also averred that while different castes have endured varying degrees of discrimination historically, but once put on a presidential list and notified the president under Article 341, they are homogeneous. They are homogeneous group, and forming subclassification inside this group is forbidden. She further concluded that states lacked the legislative authority to effect subclassification because neither the state list nor the concurrent list permitted them to do so. Thus, her opinion against subclassification offers a compelling rationale to say that it is not proper and legal. She held that subclassification by the states is nothing but tinkering with the presidential notification under Article 341 of the Constitution, and only the Parliament has power to include or exclude caste from the list, ensuring that the process remains far from political influence as per whims and fancies of the powers that be. Thus, she highlighted the importance of maintenance of integrity of SCs and STs lists, and her ruling underscores the need for pragmatic approach and systematic solutions that addresses the root cause of the marginalization of scheduled caste rather than creating further divisions within already disadvantaged communities. The ramifications of subclassification on scheduled caste solely on the basis of backwardness could be profound and even counterproductive, apart from the clear negation of constitutional mandate. At the outset, one must understand the origin of reservations of SCs and STs and appreciate that providing constitutional safeguards or reservations to these marginalized communities is not because of backwardness, but for thousands of years of suppression and social discrimination, untouchability meted out to them, and they were not allowed to have education or any helpful activity because of this vicious caste system and the discrimination it sustained against them. Reservations is a system of a positive and an affirmative action to felicitate these disadvantaged sections and ensure their representation and participation in the socio-economic and political activity of Indian society, enabling their proper representation in education, employment, and public life. Part 15 of the Constitution deals with the reservations of SCs and STs in central and state legislatures. Article 341, Clause 1, 342 of the Constitution of India defines who are the SCs and STs respectively. Article 15, Clause 4 of the Constitution and Article 16, Clause 4 of the Constitution enable the central and state governments to provide reservations in government services for SCs and STs. Article 15.4 of the Constitution says nothing in this article or clause, nothing in this article or clause 2 of Article 29 shall prevent the state from making any special provisions for the advancement of socially and educationally backward classes of citizens or for the SCs and STs. Thus, nowhere in the Constitution it refers to the backwardness criteria to the SCs, who are the victims of social stigma, untouchability, and discrimination, and some progress in social and economic sectors does not mean that they are being treated equally in all fields of the society. The idea of subclassification assumes that backward caste within the SCs and STs will suddenly achieve adequate representation. But this assumption overlooks the historical and systematic disadvantages of these groups face starting from a position of extreme marginalization. These subcastes may struggle to fill the reserved seats allocated to them. Consequently, these unfilled seats might be transferred to unreserved category, thereby undermining the very purpose of affirmative action, leading to a situation where the benefits of reservations are diluted and the intended aim is not achieved. So the assumption of this majority judgment that subclassification will lead to better representation is obviously flawed. Those who are backward within SCs and STs are often lacking access to quality education and employment opportunities and confined to do menial jobs. And without addressing these fundamental issues, merely creating subgroups is unlikely to result in meaningful representation. On the other hand, it may perpetuate the cycle of segregation and exclusion leads to marginalization and further division among SCs and ST communities, weakening their collective identity and political strength, undermining the solidarity needed to fight against social, political, and economic injustices and discrimination. So, without clamoring for subclassification, addressing the systematic disadvantages of backward sections among SCs and STs by adopting an effective strategy to enhance the targeted educational and economic support programs, such as providing scholarships, skill development programs, and access to quality education from primary level onwards, implementing mentorship and internship programs can help to bridge the gap in education and employment of these marginalized groups. The strengthening of anti-discrimination laws and ensuring their strict enforcement can also play a crucial role in ensuring a more equitable environment. So, by focusing on these fundamental issues, we can create a level playing field without dividing SCs and STs on the pretext of backwardness. That apart, even going by the judgment, the subclassification cannot be made by whims and fancies of the government. It has to be based on empirical data of all subcastes and identification of most backward among such groups. For this purpose, the collection of accurate data on socio-economic status of each community among SCs and STs is a must, for which a caste census is required. Caste census in India is to provide necessary empirical evidence to formulate such policies. Conducting a caste census would reveal the true extent of economic and other disparities within these communities, debunking the myth of rich or poor among SCs and STs and even the OBCs that has been propagated and perpetuated by the Savarna caste to justify the systematic discrimination and division among marginalized sections of the society to weaken their collective bargaining power and unity. The present RSS-led Modi government is totally against caste census and deliberately avoiding, in spite of vociferous demands from many state governments, political parties, civil societies, and more particularly the SCs and STs and OBC organizations throughout the country, due to its apprehension that it may give rise to increased consciousness among SCs, STs, and OBC communities and expose its Manuvadi Brahmanical hegemonic communal majoritarian divisive agenda. The reality is that despite some individuals or families from SCs and STs achieving some level of economic success or getting employment, their overall status in the society remains unchanged and significantly is lower than the general sections of the society, and they face discrimination everywhere, which cannot be denied or undermined. In view of these facts, and the circumstances existing. With due respect to the honorable judges, I am constrained to say that the judgment of the majority judges in SC classification is totally sidelined the exacting socio-economic status of SCs and not reflected the spirit of constitutional mandate in providing reservations to SCs and STs, and it needs to be reviewed. by another larger or full constitutional bench, taking into consideration the strong and very constructive dissenting judgment of Honorable Justice Bala M. Trivedi. Pending such review, it is my earnest appeal to all sections of the scheduled caste not to carry away by the temporary emotions on this issue by fighting for and against the subclassification judgment while adhering to their respective views on the subject, and do not become the victims of conspiracy of communal majoritarian hegemonic forces who are gleefully watching the internal fighting among SC groups on the issue, while SC groups on the issue, and they are watching and they are enjoying this deepening divide among marginalized sections of the society, particularly among SCs. While engaged in this internal conflict, the SCs are ignoring the fast eroding their due quota of reservations and employment opportunities due to the total privatization of all government departments and undertakings, with the sole intention of denying their socio-economic advantages, socio-economic advancement, and to do away the reservations altogether. Instead of unitedly fighting for the reservations in private sector as well, I sincerely hope that the better sense will prevail on these embattled groups of SC community to come to the reality and to stand united to safeguard their collective rights guaranteed by the Constitution of India, authored by the great visionary Baba Saheb Ambedkar. Thank you. I hope that you will appreciate this presentation and be united. Please be united. Stand united and get our rights protected. Thank you. Jai Bhim, Jai Bharat.